Welcome back to the Crypto's Key Conversation. We're going to jump straight into James K. Fallon. He has an update here for us. Let me zoom in here. It says Ripple files letter regarding recent Supreme Court case that supports Ripple's fair notice defense. Quote, this opinion strongly supports defendant's fair notice defense because the government's prior guidance appears to contradict its present litigating position. Coming down here, XRP Crypto Wolf says Ripple knows they're going to win in Ripple court, in regular court, and even in the Supreme Court if the SEC takes it that far, with the laughing emoji. And a lot of us in the community have been having sharing that same sentiment. It's been evident based on the victories that Ripple's had in litigation and just the overwhelming evidence that's going against the SEC that's been presented so far. Jeremy Hogan's responded to James K. Fallon and says Ripple just filed a strong case supporting its fair notice offense. Strong because it comes from the U.S. Supreme Court. It states that regular-ish people like you and me need to have guidance and know what the laws and rules are before we are sued, which is, I mean, you think that'd be common sense, right? And the SEC aren't idiots. Like they know what's up, but they're just trying to take full advantage of the power that they have. And that's what we keep talking about on this channel, is stretching their tentacles as far out into as many things as possible, before they get the hammer dropped on them. If it ever comes. John Dean continues to talk about, 2025, late 2025 being the year and time where we actually get some regulations within the space outside of the Ripple versus SC stuff. It's crazy, man. John Deaton has this great thread and is talking about the supplemental authority in support of fair notice defense that we just talked about from James K. Fallon and Jeremy Hogan. He says a lot of people are speculating on why Ripple would file this now. Some people are saying it's because Ripple knows it will lose or because they are less confident. It's a very simple reason why it was filed. The decision is from the Supreme Court and it was handed down only 4 days ago. He continues, George Torres could possibly file her decision at any moment, or it could be 2 months longer. The point is, this isn't a decision from a federal district court or even an appellate circuit court. This is a U.S. Supreme Court decision decided on February 28, 2023, 4 days ago. The Supreme Court decision is relevant regarding one's Ripple's affirmative defense. The lack of fair notice violates the due process clause of the U.S. Constitution. People overthink and try to look for reasons other than the obvious one, which is, obvious why people think that way, especially within the Twitter community. People are just panicking, people are impatient, and we just really don't understand, the ins and outs of legalities of the legal system, just like, like John Deaton and Jeremy Hogan and, James K. Fallon and the like. We're just everyday people, but obviously people are speculating because maybe they have something vested in, maybe they're panicking about, the SEC's overreach into this space, and, they're panicking because of, their digital asset might be next on the chopping block, who knows. But I think certain speculation, especially when you're just wondering and you're trying to get answers, is okay. But this whole, trying to create narratives, trying to make sense of things, it's almost like merely interesting. And we shouldn't, in a sense, kill ourselves trying to figure out things and trying to make sense of things to this degree. Obviously, we have people within the community that can, tell us what the facts are. And here's what he's trying to prove here. He continues to say, essentially, Justice Gorsuch elaborated on the requirement under the due process clause for the government to provide fair notice of what is prohibited. Quote, as in Bittner, the government's prior guidance appears to contradict its present litigating position. And as in Bittner, many experienced securities law practitioners and industry participants were unable to anticipate the government's current theory. He continues, that's the reason it was filed so late. If Judge Torres finds that Ripple offered and sold XRP as a security, this Supreme Court decision gives Ripple's fair notice argument a few more teeth. Which, when it comes to battling against the SEC, just the every little percent inch, as he says, few more teeth, that's necessary. So this is huge to hear. Then he concludes here, he says, I've already went on record to say that I have no doubt Ripple wins before this current Supreme Court. The West Virginia versus EPA case alone is the reason to believe Ripple wins. The recent decision is icing on the cake. So shout out John Dean for always keeping us in the loop and really keeping us grounded. And I'm speaking mainly for myself. And I hear, a lot of sentiment within the community. Without, these legal representatives in our community, man, I don't know where we would be. Literally, it would just be wild speculation, as they like to call us. Because we wouldn't understand any of this. And quite honestly, we'd probably just be getting taken for a loop even worse than we are now. So coming on to the next here, John Dean's responding to the Wrath Economy here. It says, in the article, Stuart Otterati notes, if the judge sides with the SEC, Ripple can and will immediately appeal. and that, quote, I would be supremely confident that this is a winner in the Supreme Court. So really take that into heart, okay? So remember, a lot of people within the community are panicking and stressed about the potential of Ripple and the SEC taking this to the next stage and going to the Supreme Court and, pushing this thing further out, right? So you got to keep that in mind, because Ripple is a for-profit company, right? They're private. So obviously they got to do what's best for them, their investors, and their company. When it comes to the XRP holders and investors, they're not representing us. Obviously indirectly they may be representing the industry, but they're not in court representing us, they're representing themselves. So luckily we have John Deaton stepping up, and he saw there was a need, obviously not just for the XRP community, but for the entire industry. So here's what he's going to say. He says, this is the number one reason I filed the case versus the SEC and fought so hard to be involved in the case on behalf of token holders who purchase XRP in the secondary market. A possible result is that Ripple loses, but secondary sales are classified, even if it's just dicta. He says Ripple can afford to appeal because the status quo would continue. For example, ODL continues and Ripple can still sell XRP while the appeal is pending. XRP holders, developers on the XRPL, etc., are not in the same position as Ripple, hands down. And we got to count our blessings, man. Having John Deaton and he just one powerful representative we have, just having him in the community is huge. And I can't stress that enough. And I want to shout out Tony Edward from Thinking Crypto, man. He had this. Does a great job with all his content and having all these interviews. I just listened to the one with Hester Pierce again while I was cooking dinner for my boys, and I love that we have a voice like his and a platform that welcomes representatives, and they come on and they share their ideas and how they view outcomes and how things are happening within our markets, man. I mean, without that, it'll still just be like guessing game and speculation. So I want to shout out Tony Edward for doing that strong work and always being consistent with it. He's responding to TCB here. So TCB says, SEC blocks deal where creditors would see a 73% recovery rate. 97% of customers voted in its favor. They are the destroyers of value. In no way do they act as protectors of investors here. Gary Gensler is a crook and needs to step down. So he's responding to this CoinDesk article where it says, Voyager bankruptcy judge says he is absolutely shocked by SEC objection to the Binance US deal. So you can come in here and read these highlighted parts, or you can just come in and read the article. I highly recommend you do, because it all ties into the SEC's overreach and overregulation by enforcement within the space, clearly not here to protect the so-called investors they're set out to protect. Tony Edwards says, by now everyone should know that corrupt regulator Gary Gensler does not care about retail investors. He cares about protecting the banking incumbents and pocketing the millions he gets from shaking down companies. Even the judge is calling out the SEC and their nonsense. Why didn't Gary do his job in reviewing Voyager, FTX, Celsius, etc. before they imploded? He just let them collapse knowing investors would get hurt. Now he is trying to block any bankruptcy efforts that would help investors. And then he puts like the shame emoji, hashtag Gary Gensler resign. Obviously, I talk a lot about how I feel about how things are rolled out per the chairman of the SEC, and not even just that, like other representatives that are kind of just sitting on their hands, sending letters and having conversations, saying all the right things, but not really taking action. But Chairman Gensler, when I say, the ruiner of many lives, many financial plans, many goals, I mean, literally, and this is the same individual who on the taxpayer dollar is meeting with his representation for his fortune that he has, I think it was like over 120 million or something, and he's meeting with these representatives on taxpayer dollars, but he can't even respond, let alone have a meeting with John Deaton and the 75,000 representatives or XRP holders that he's representing. But he's having meetings with his personal things and people that it's odd that he should be having meetings with. And this isn't anything new to us. It's not like we don't know about this stuff and then hiding stuff and redacting stuff from his supposedly public calendar. How is this even how is this happening? Why is this not being stopped now? What is Congress's plan? I mean, even here in Hester Pierce talk on Tony Edwards' interview that they recently had, it makes no sense why, if we have people within the SEC themselves saying, hey, let's try A, B, C, and D. Let's just roll this out and see how it goes and then make the adjustment. Why aren't these things being taken into consideration? She also mentioned that, this thing takes time when it comes to this. You may have an idea or a thought and it may take years for them to be like, oh, yeah, let's try that. Well, there's billions and billions of dollars and many families and investors that's been affected. Look at the chaos that's been happening, let alone in 2022, but just in the past few years alone. Why aren't we taking, the action as they take, how they do the, whenever there's like a crisis, right? They have that philosophy, never let a crisis go to waste. There's a lot of disaster and destruction that's been happening. Why not implement some things to try to alleviate that? Why are we trying to play catch up when we don't have to? That's the big question. And I know Tony was trying to get to that, and I didn't finish the whole entire interview before I started this, but he was trying to get some more information. Obviously, Hester Pierce can only say so much, but it's interesting, man. I wanted to play this here. This is from XRP Darren. So remember, we put up Brad Garlinghouse's interview yesterday when he was pretty much calling out the SEC and their actions within the space. So he goes, old slithering snake Gensler responds to Brad Garlinghouse's claim that the SEC is regulating by enforcement. Let's take a quick listen into this.
In the ecosystem, the Ripple founder had to say a little bit earlier, if you could just take a listen.
The SEC is kind of playing offense and attacking the whole industry. This is not a healthy way to regulate an industry. Regulation through enforcement, as opposed to where we're seeing in other countries where they're doing the work, right? They're codifying, they're creating a framework that allows an industry to grow while protecting consumers. And I think that's really what the U.S. is lagging.
Now, Chair Gensler, I'm pretty sure you might say, well, look, a founder in that sort of business might be saying this, but what about some of these players? Like we've spoken to many who've perhaps been part of previous administrations who are now, advisors to some of these companies and worried a little bit about the holistic nature of really trying to regulate and worried that it is more about enforcement rather than the rules of the road at the moment.
Caroline, there's nothing incompatible crypto in our securities laws. Our securities laws were brought about to protect the investing public against fraud and schemes and manipulation. And it was through this idea of full, fair, and truthful disclosure, registering with the SEC when you're raising money from the public and the public's anticipating a profit. It's pretty straightforward, actually common sense approach to helping the public in investing. So this broad field, we have one goal at the SEC is for them to come into compliance, whether it's the tokens, that's basically people raising money or offering these tokens. And it's also what I'll call the storefronts, but they can call themselves crypto exchanges or lending or staking as a service or other intermediaries to come into compliance and ensure that they don't mislead the public, but also that they don't commingle the funds, they don't take the public's funds and do things we just don't allow in our financial markets. We don't allow the New York Stock Exchange to also play with the customer's funds and make markets, run a hedge fund, run a dealer, be in the clearing business. We separate out those conflicts.
Mr. Gensler, thank you for your time. You've set out the goal there. And what I want to ask you about is the results of your actions. You have asked a number of names in the crypto industry to register their products with the SEC. Very few have, in particular, those that are most known to us, the bigger names in the industry. Why are they not acting on your requests?
Well, the law is the law, and they need to come in and properly follow the laws, and we will work with them to do that.
So clearly, Chairman Gensler can give two craps about Brad Garlinghouse, Ripple, the investors that he so-called set out to protect. I just took a few notes throughout this clip here, and he's talking about, and he just says it so arrogantly, like, he's talking about transparency and fair and order disclosures. It's like, okay, well, he doesn't even follow that himself with his fortune, which that's been exposed on this channel and within the community as well. But then again, it's like he's saying things are straightforward and it's quite clear. But it's like whenever you were asked about things, Ethereum status, why are you talking about you're the cop on the beat or whatever, but you're letting all this destruction happen. Then you're going after at the end and trying to, kind of undermine things and get your cut out of it. Like if it's so straightforward, then why, when it comes to these entrepreneurs and these companies, why are they struggling so hard to understand what the heck's going on? Even the people within the industry like me, like within, as the investors, it's like, what is good and what is not? You have Ethereum, and I'm not hating on Ethereum. I hodl Ethereum. You have Ethereum's co-founder Joe Lubin talking about the things that Chairman Gensler just talked about. He was just saying like it was pretty much a no-no, the lending, the staking, and all those things, right? You know, you got to come into compliance. That's not a thing that you could just do, right? But then you have Joe Lubin gloating on multiple videos, visually him doing it, talking about those things, and it's still a thing. Why haven't they held the same standard across the board is the question. But it's supposed to be quite clear and it's straightforward. It's not. And it's just shameful because it's evident. And then when he says we have one goal, I thought he was going to be like, oh, you know, investor protection like he normally does. But he says one goal is coming to compliance, right? How? Compliance how? How are you applying this compliance to these digital asset companies? There's just too much confusion. So it's not straightforward. Even representatives that are working with him at the SEC are confused. It's not quite clear. It's never been quite clear. It's crazy. We're going to move on to this clip here. This is Joe Lubin and DAI. It's always doing a solid job of putting this stuff up. This was on, February 27th of this year. Joe Lubin agrees Ethereum is not decentralized, but, quote, we're working on it. Unbelievable. They've had this fake commodity designation since 2018. Corruption. Yeah, corruption at its finest. Let's take a quick listen into this.
I wanted to ask.
Give him the hat.
How can you call Ethereum decentralized if more than 60% of the blocks are sanction compliant with the United States? That is not decentralization.
Yeah, so decentralization is a process and a trajectory and an intention. Ethereum has never. You could call it a vibe if you want to. Bitcoin started centralized, Ethereum started centralized. We've been doing our best to be focused on defining decentralization across as many different dimensions as we can identify. We've done a very good job of getting increasingly decentralized. Projects on Ethereum have done a good job of finding product market fit and then progressively decentralizing. There are 300,000 and something, 350,000 different validator nodes. We believe there are maybe 80,000 different individual actors that control those nodes on Ethereum. There are protocols being built that will make Ethereum censorship resistant at the protocol level. I agree with you, but we're
There he goes, holding that elbow that we've been in the community talking about. That's when he's, lying and covering. Here's the thing. Remember, he's just said, we're working on it. It's being built. These things are being implied. But remember what Chairman Gensler and the SEC were talking about. It's like, if you're building out, which I think they went after Library hard with this, if I can remember correctly, if they're continuing to have to build out, then they classified it as a security, right? I mean, what is he saying here? All the verbiage and words that he uses is stuff that Chairman Gensler contradicts himself on. It's just shameful, man. I'm going to come over here. We're currently sitting at a $1.07 trillion market cap. Bitcoin sitting at 22,352. Ethereum sitting at 1571. XRP is sitting at 37 cents. We come over here. Bitcoin Fear and Greed Index sitting at a 50. We're at a neutral. Just a matter of just kind of waiting it out, kind of see how things progress. We'll see what happens. Make sure you come to the Crypto's Key Conversation YouTube channel, subscribe, and follow us on Twitter at Crypto's Key 1. I really appreciate your support out there. With all that being said, stay strong out there and be safe.